found out I was pregnant, and in my early second trimester, found out that the baby had multiple fatal anomalies that meant he wasn't going to survive.
One of the most challenging aspects of practicing in obstetrics and gynecology is that we see some of the happiest times in a woman's life, and we also see some of the saddest. And early on, it was apparent to me that how we care for that patient in that moment of real trial is so critical to their health and future.
They delivered incredibly devastating news, and in the same breath said that I had no options in Texas, and that even though my baby wasn't going to live and could die in my womb at any moment, that no one had yet been criminalized for leaving the state to end a pregnancy.
Let's be clear about what the law is in Texas. Only a physician may perform an abortion, and that physician may only perform an abortion if he or she determines in the exercise of reasonable medical judgment that the woman has a life-threatening physical condition that either puts her at risk of death or at substantial risk of impairment of a major bodily function. There's not absolute clarity, however, again, on how sick the woman has to be, how soon the risk of death has to be, how high the risk of death has to be. And most doctors will tell you that it's already a challenging standard because the very fact that a woman is pregnant already means she is at a greater risk of death.
So the heartbeat bill is what we think of as Senate Bill 8, or the chapter in the code that creates a civil cause of action where people could sue someone who helped a person get an abortion that didn't comply with the requirements that a heartbeat not be detected in the pregnancy before the abortion was performed. The trigger ban is called that because it was not triggered and did not go into effect until the Supreme Court overturned Roe in the Dobbs case. So it is the felony criminal abortion ban with the severe civil penalties that the Attorney General can bring also.
In 2021, in anticipation of possible action by the Supreme Court, the Texas Legislature passed both SB 8, or the Heartbeat Act, and the trigger law. And SB 8 had an immediate effect. And once the trigger law took effect, Texas has now several prohibitions in various statutes against abortion. They don't all have the exact same wording. There are no exceptions for rape and incest. And there is still uncertainty about whether the laws that were struck down by Roe are still in effect.
All abortions are illegal unless, using reasonable medical judgment, it endangers the life of the mother. The big question for us now is, well, who defines reasonable medical judgment, right? So we used to think, well, physicians decided what reasonable medical judgment is. And what we've seen in several cases, particularly the Kate Cox case, is that even if a physician thought it was reasonable medical judgment, the court then upheld it. Then the Supreme Court of the state of Texas came back and said, no, that doesn't qualify. So who decides this? The courts or the physicians? So let's put yourself in a physician's shoes, all right? You have a patient who has a major issue, all right? She has uncontrolled hypertension, all right? And she has kidney damage from this. And continuing the pregnancy is only going to worsen her kidney damage and worsen her hypertension. And it's been recommended that she needs a termination of pregnancy. So here are your choices, all right? You can go through with this, and you can risk life imprisonment. You can risk $100,000 fine and loss of your license, as well as anyone around, whether it's a hospital employee, whether it's a relative of the patient who hears about this, can then bring another suit against you, all right? And yet, you're not protected by your malpractice insurance carrier or by your institution. Would you want to do that? Most people don't understand, and many don't realize, that if you have civil litigation brought against you, or that you are charged with a crime in a situation like this, that your malpractice carrier or the institution with which you're affiliated will not have your back.
What's happened since 2022 is all conversations are fraught with the peril of what if I'm misunderstood? And I feel this coming from patients towards me. They wonder, can they trust me? And I wonder what their positions are on pregnancies when things are going wrong.
If I cannot give my patient the full spectrum of consultation on risks, benefits, and alternatives, then we have short-circuited the informed consent procedure.
One of the scenarios that I think is the best to kind of define how women are hurt. I have a patient who is very public in her story. It's been in other news stories where she had a pregnancy that was strongly desired. She'd done multiple rounds of in vitro fertilization to create this life. And I remember this day. I walked in a 12-week ultrasound and had to tell her this baby had very rare numerous malformations that were incompatible with life. It's a 1 in 100,000 scenario. But in Texas, she has no right to do anything. So I can't even talk to her about options, because, we're also fearful of, this aiding and abetting sort of situation. Thankfully, my patients are sophisticated. She knew her rights and she knew that she had the right to travel to a different state. But that takes time. Right, our neighboring states are overwhelmed with other Texans in this scenario. So she traveled to Colorado, and by the time she got in, it was 17 weeks. There's a very rare placental problem called an accreta, where the placenta actually invades through the uterus. She had her procedure done and immediately had life-threatening hemorrhage or bleeding out, where she was at risk of, losing her life, losing her uterus. And she had a procedure done emergently called an artery embolization, which thankfully stopped the blood flow and thankfully saved her uterus and her life.
We still felt hopeful, and I still, wanted this so badly. And we began seeing specialists, and there were many scans. And we looked into all of that until they told us that he was dying and that he was experiencing heart failure and adrenal failure. And that it was just a matter of time until he was going to die. And we didn't know when, but he was going to die inside of me.
To care for a patient that's carrying a fetus that ultimately will die is truly heartbreaking. Every time that patient comes in the door, that there's a chance that fetus may have lost the heartbeat, which in some situations may even be a small mercy for that patient. But for a patient that carries to term, that patient is dealing with not only the physical implications of being pregnant, but also the emotional distress of walking around the grocery store with everybody in public knowing that person is pregnant, asking the same questions they would of any pregnant patient that they see. And it just adds insult to injury. To have a patient like that come to deliver a baby that is going to die is especially heartbreaking. I have the privilege of having held hands with patients that have been in that situation before. To see a patient deliver a full-term baby that will then suffocate and die in their arms is a pain that I don't wish everybody has to see to understand why access to abortion is so important.
Let's say my patient has an anencephalic fetus, a fetus without a brain. This fetus will not survive after delivery. Everyone knows that. So, currently, that patient has to carry that baby until she goes into labor, deliver that baby, and see that baby die in front of her. For some women, that may be the right answer. That may be the right way to deal with the grief that she will feel. For others, that may be the source of PTSD for the rest of their lives and affect not only future childbearing, but their relationship with their partner. That's a devastating thing. That woman should be able to make that choice, not our legislator.
When I was first married, I got pregnant with a very much desired pregnancy. Unfortunately, I was diagnosed with trisomy 18, which is not compatible with life for the fetus. The fetus was diagnosed with trisomy 18, and I had to make a decision about whether or not to terminate the pregnancy. Ultimately, I decided, with support from my husband and my church, that I was very engaged with and part of a strong Catholic community, to not terminate the pregnancy. And ultimately, I went to full term 9 months and gave birth to a fetus that did not live. The baby was stillborn. It was a choice that I made. By the grace of God, I had support. It was a moment that changed me forever, and I don't regret the decision I made. What I do regret is that there are women, all women who face this in the future because of the extreme abortion ban, will not have that choice to make. They will not have the opportunity to figure out what's right for them, to figure out their path, their faith path, right? And their path for their family, because government has already made the decision and compel women to go to full term 9 months for a fetus that will not live, that is terminal.
I'm aware that people are saying that doctors should be able to figure this out. But what you need to understand is that there's not a law in the state of Texas about abortion care. There are a handful of laws that impact abortion care for women and impose various degrees of potential criminal and civil liability, as well as adverse action by the Texas Medical Board. All of those taken together are hard to interpret. And when people point to, oh, there's an exception for medical necessity, there's an exception for emergencies or critical aspects without the specific law, the statute in front of me, I'd be hard pressed to respond on exactly what that means. And even with the specific language of the statute in front of me, people can differ in interpretation. The problem for the physicians trying to provide this care is that they are potentially liable for civil and criminal liability, loss of license, and imprisonment. So what are they going to do?
Even in a routine pregnancy, we know 15% of women suffer from postpartum depression. I can only imagine somebody who carries a pregnancy that was never going to survive. That rate is higher, right? You know, we see women have postpartum depression that leads to suicide. You know, so there's so many repercussions of forcing someone to carry this pregnancy to the point. The second part of that, just from a health standpoint, pregnancy itself is dangerous. You know, being pregnant, you have a 30x time of a blood clot versus non-pregnant. We talked about my patient and this life-threatening condition that would have happened that would have caused a hysterectomy. But just other things, you know, like if high blood pressure pregnancy, you know, it is, you know, I take care of a lot of older mothers. Preeclampsia or high blood pressure is a real risk. A woman who develops preeclampsia has future increased risk of any cardiovascular mortality. You know, 1 in 3 women die of heart disease. So you can actually say that forcing someone to carry a viable pregnancy that leads to potentially preeclampsia, we've probably taken years off that woman's life. You know, so I would argue that these are not laws that are protecting the sanctity of life. You know, they're actually shortening or hurting life.
Texas has been sort of a laboratory for regulating this area of law for a long time. And I think that has now created this patchwork situation that we find ourselves in. And it's time to sort of step back and think holistically about the care that we all agree should be provided and how we can tinker with the laws or create a little space among the laws to make sure that care is still going to be provided.